Good afternoon, everyone. Sorry for that slight delay. My name is Mike Harrington. I'm the chair of our Labor and Employment Group. Good afternoon, everyone. Sorry for that slight delay. My name is Mike Harrington. I'm the chair of our Labor and Employment Group here at North Carolina. Thank you for joining us. As you may know, we offer webinars each month so that we try to keep you as up-to-date as possible regarding labor and employment matters. All callers are going to be in listen-only mode. If you have any questions during the presentation, you can write them in the question box of your webinar toolbar, and we'll answer them at the end of the presentation. All of today's participants will receive an email from Jackie Rowe after the webinar with the PowerPoint presentation and an attendance certificate for you. So today we're talking about two issues, and I know I've mentioned this before, that if there's any topic of interest to you, please let us know so that we can present on it. Today's topic, the first part, was actually recommended by a client regarding intermittent leave, and we're going to talk about that. In the recent time, there's also been a new development in Connecticut law regarding pregnant accommodations that employers have to make for pregnant employees. So, and those new requirements are going into effect on October 1st, so we wanted to address those in today's presentation. Now, you might remember from a prior presentation that there are a variety of places or sources that people may gain a right for leave. FMLA in particular, Paid Sick Leave Acts, and that more and more states are passing Paid Sick Leave Acts. The Americans with Disabilities Act, Connecticut's Fair Employment Practices Act, and so forth. Today we are going to be focusing on FMLA, both state and federal, for purposes of discussing intermittent leave, and we're first going to discuss the Connecticut Fair Employment Practices Act provision for accommodations for pregnant employees. Okay, so currently, and some employers still are unfamiliar with this provision, which has been around for many years now, with regard to special provisions that have to be made for pregnant employees. And these provisions are subject or govern employers with just 3 or more employees. So nearly every employer in the state of Connecticut would be subject to these rules, and they kick in immediately. They don't have a qualifying period like FMLA does. And as you can see, I won't go over each and every one. The sum and substance is, under Connecticut law, it's illegal to terminate a woman because of her pregnancy. And more particularly, you have to make a reasonable effort to either transfer that employee to an available temporary position if they are unable to perform their current job because of their pregnancy. And you also have to provide a reasonable leave of absence related to the pregnancy, related to the disability due to the pregnancy. And so, unlike FMLA, which has a very specific period for the leave that must be given, this is more dependent on the particular facts of the circumstance of the woman's pregnancy. So, for example, if someone has a very healthy pregnancy, they may not need any time off prior to delivery. And if their delivery goes well, they may need typically 8 to 10 weeks is what a doctor may disable them for as a result of the pregnancy. Now, someone who has a complicated pregnancy, may require leave prior to delivery and additional leave after delivery. So if you're in one of these situations, you need to simply ask your employee for a doctor's note indicating what is the period of anticipated disability related to that pregnancy. I will tell you that the statute does provide for that the leave has to be reasonable, and what is reasonable has never really been litigated in the state. So it's difficult to say for certainty what are some parameters. But I think much like when you get to ADA issues and you talk about undue hardships, those sort of considerations may come into play. So if you're a small employer and someone has trouble with a pregnancy very early on and they're a key employee for their particular function and you won't be able to manage for, let's say, 10 months without them, maybe you have an argument that their leave of absence would be unreasonable. But as I mentioned, it's very much fact-specific, and it will be determinative on the facts of your case. Now, so what's happening? What's the new law going to provide? Well, it's certainly providing more rights than currently exist, and in particular, the leave provisions are largely the same. The failure, the prohibition against discrimination is generally the same. But one thing you want to take note of is when it comes to transferring someone, you can't force someone to take an accommodation if they feel they do not need it. I guess the legislator had heard some stories where women were forced to leave their positions before they thought they needed to as a result of their pregnancy. There cannot be any retaliation. And what's also very new in the law is the definition of pregnancy has been expanded to include lactation. We had a mandate to provide reasonable breaks for lactation, but now this is being incorporated into the comprehensive anti-discrimination provision dealing with pregnancy. And we also have a little more guidance about what a court would have to evaluate in determining whether a leave of absence was reasonable or not. And so one of the things, you see this very specific list of things you might want to review before making any final decisions. So reasonable accommodations include, but certainly is not limited to, being able to sit while at work, more frequent or longer breaks, periodic rest, assistance with manual labor, if that is a component of the woman's job, possibly restructuring the job for the period of the pregnancy, possibly giving a light duty assignment, modifying their work schedule, trying to provide transfers to less strenuous or hazardous work, and obviously giving time off to recover from the pregnancy. And they've also included into the statute, providing break time and reasonable facilities for expressing milk, which was provided elsewhere prior. And when it comes to an undue hardship that may alleviate or avoid an employer from having to provide those accommodations, these are the factors that are going to come into play. What's the overall cost of the accommodation? What are the financial resources? So not all employers are going to be evaluated on the same footing. It's very much going to depend on the size of the employer. And also, what's the effect of the expenses or resources of the accommodation on the overall operation. I think if an employer is going to decline to provide a requested accommodation, you might want to seek out legal counsel and really think long and hard before doing that. Not surprisingly, I think sympathies will lie with the pregnant employee, and the employer really is going to have to meet their burden of being able to show that undue hardship. Okay, one other new component to this statute is you must provide written notice to employees about their rights in the statute. Now, you can satisfy this with a poster, which I believe the Department of Labor is working on, but I'm not aware of it being prepared yet. So prior to October 1st, if the posters are not available, you may want to send a notice to employees or incorporate a new provision into your handbook so that people know of these new provisions. Okay, so now we're going to turn our attention to intermittent FMLA. Now, as you know, FMLA there's two forms of FMLA that cover employers here in Connecticut. Our federal law governs employers with 50 or more employees. Our state law governs employers who have 75 or more employees. And there's certainly those qualifying thresholds for employees to be eligible to take FMLA. They have to work for a year and work a requisite number of hours in the preceding 12-month period, either 1,250 for federal law or 1,000 for state law. And so in some circumstances, certain folks may not be eligible for this leave. But for the ones who are, leave can fall into three different categories. You can have your continuous leave, where someone needs a solid block of time off from work, clearly, typically after surgery, where someone's recovering. This will be the case. But you also have intermittent leave, which we're going to be discussing in detail shortly. And those are occasions where it's not a continuous block. These are occurrences that come up unexpectedly, or they may be on some schedule, but they're smaller blocks of time that recur over some period of time. And then there's the type of leave where you can work a reduced schedule, but just not your full schedule, and so you want to take advantage of FMLA for the period of time that you cannot work. Okay, so intermittent leave can be taken for these various reasons. Obviously, recovering from your own health condition, dealing with a family member, a covered family member's health condition, caring for a service member who's covered by the statute who has a serious health condition, or dealing with the qualifying exigency that may arise out of a family member's service and your employment. What's not on this list is dealing with the birth or adoption of a child. For that, if leave is being taken for that reason, it must be taken in a continuous block. It may not be taken on an intermittent schedule. Okay, so the real goal of this talk is to try and give employers some ideas of how to manage and avoid abuse of leave. This is certainly, from my perspective, from what I hear from clients, one of the more challenging roles that or functions that HR must do is to try and deal with intermittent leave. And when I've talked to clients, I frequently remind them, let's imagine that there is no abuse afoot. This person is truly dealing with a serious health condition that occurs in sporadic, unexpected ways. And some frequent examples surround or involve migraine headaches, back spasms, epilepsy. These are things where your employee may not be able to anticipate and give you much notice, but when they occur, they are going to render them incapable of working, and they'll want to take advantage of FMLA because it's a qualifying serious health condition. So in dealing with potential abuses, you want to make sure your process is well thought out and followed so that if there is any abuse, it may come to your attention. And it begins with the original certification. So when someone needs FMLA, the employer is entitled to certain information on a certification form. You don't have to use the government's form, but it's certainly a good form to use because they put it out. And you're entitled to information such as when did the condition begin, what's the likely duration, any relevant facts that the employer may need to know to accommodate that condition. and obviously some sort of statement that because of the condition, they're unable to perform the essential functions of their job, or they're needed to care for their child, parent, or other covered member of their family. So it would not, not all employers are very good about making sure their certifications are in order, but you want to make sure they are, so that they are a solid reference point going forward, so that when someone calls out absent, you can refer back to whether that absence, qualifies for FMLA leave. I mean, there may be situations where I have a certification for FMLA leave, but I need an absence for some reason other than FMLA leave. Simply because I have migraines doesn't mean I might not need a leave of absence because I have a head cold one day. And those need to be tracked appropriately, and we're going to talk about that. So you want to make sure the certification is complete, it's sufficient. You want to make sure on its face it appears authentic, and you certainly want to make sure it's legible. If any information is incomplete, you can certainly ask for clarifications, and if something's not legible, you can ask for that to be clarified. Now, if you have some doubt about that certification that you receive, employers do have rights to pursue a second opinion, and in some cases, a third opinion. Now, when it comes to second or third opinions, the employer is going to have to pay for the cost of those. If the second opinion is at odds with the first opinion, a third opinion can be sought, but the employer also has to pay for it, and that opinion is going to be binding. And the employee has to agree to the physician who will be taking the third opinion. What's important to know is, and we're going to talk about a right that the employers have for recertification, but you cannot seek second or third opinions for recertification, only for the original certification. So if you have doubts regarding that original certification, you want to deal with them in a timely manner. Okay, third, and this goes back to a point I was just making. Not every absence that an employee takes may relate to FMLA, even if they have a certification. So you really want to track and properly record the reasons why someone is calling out absent. They may call out absent because their car battery didn't start, or because they can't get out of the driveway because a tree fell down. But those obviously are not going to trigger at all FMLA. And the reason why you don't want to track it is, one, you want to see if there's any patterns that would suggest abuse, such as them calling out only on Fridays or Mondays or before a vacation day or before a holiday. But you also want to make sure that you are tracking it so that the employee gets the proper amount of leave required under state and federal law. If you're not properly tracking it, you'll never know when the employee has exhausted their leave. And some employers are very good about tracking, others aren't. And in tracking, you want to identify for yourself, how does your organization expect employees to report their absences? Do they leave it? Do they just need to call in and leave a message on a line? If so, you need to make sure those employees are trained to provide that they have to provide the reason for their absence, because otherwise you won't know whether it's FMLA leave, qualifying leave or not, or if they are expected to call a certain individual, sometimes their supervisor, sometimes they're expected to call HR, whoever they're expected to call, you want to make sure those people are trained to ask, why is the person absent? Now, they don't need to get into the nitty-gritty details, but they do need to know, is the person calling out for a reason related to an FMLA certified condition or not, so that they can properly track that. And then once they know that information, somehow they have to be given a procedure on how to capture that information so that it can be properly tracked. One thing I want to just remind folks of is a lot of employers have adopted no-fault attendance policies that provide for certain levels of discipline at certain levels of absence. So if you're absent 5 times in a 3-month period, you may get a written warning. If you're absent 6 times in that same 3-month period, you may get a suspension. You know, the different levels vary employer to employer. But what's important to realize is that you cannot discipline someone for an FMLA-related absence. And similarly, although we're not talking about it today, you can't discipline someone under most state law that provides for paid sick leave. That's certainly true of Connecticut and Massachusetts. So this is another reason why you want to be tracking the reason why someone is out absent, so that you can make sure you don't run afoul of those laws. Okay, 4. So what you want to do is sort of, what is your process for using paid leave? Now, FMLA provides rights for employees to be absent and not have their job in jeopardy. But employers frequently have paid leave provision or benefits for their employees, and certainly in states such as Connecticut and Massachusetts and New York, there is right for paid time off mandated by statute. For the time that leave is given over and beyond those statutes, you have the right to develop policies about what an employee must do in order to access that paid time. They may need to provide notes. They may need to provide, fill out a written slip. Whatever your policy rules are, you want to make sure that if you are going to pay the person pursuant to that policy, that those policies are followed, and first and foremost that they know about them so they can follow them, but then they do follow them thereafter. Okay, so when it comes to intermittent leave, frequently employers will want to have recertification, because the nature of the condition is one that it goes on for an extended period of time. It may go on for the person's life and their full tenure of employment. And so that original certification sort of starts the right to the leave, and then the employer may want to recertify to make sure that there is still an ongoing need related to that condition. Now, if the employee becomes subject to some new condition, a new serious health condition, then you can get a new certification for that, and then if there's and that condition may simply require continuous leave for a certain block of time, or maybe it requires on its own intermittent leave. But when it comes to recertification, you have to generally wait for the original certification to expire, especially if that certification is for 6 months or less. If it's longer than 6 months, then you can ask for recertification after 6 months. Generally, you can't request recertification more than every 30 days, but you can ask for recertification if the person is asking for an extension of an existing FMLA leave. You can also ask for it if there is reason to believe there is abuse. And there are some other reasons that are up on the board, up on the slide. Certainly at the beginning of each leave year, you can ask for new certifications or recertifications. But if there are certain conditions, if certain circumstances exist, you can require for recertification more frequently than the 30 days, such as if the reasons for the existing certification have changed. There's some new development. You can follow up on that with a recertification. Or if there's some information that the employer has received that casts doubt on the employee's stated reason for the absence. And in a day and age of social media, there are fairly frequent occurrences where employers receive such information. Someone says they're out on an FMLA leave because they can't get out of bed, and you somehow learn, sometimes from a coworker, that that person is at the beach or on the ski mountain. And so certainly then you can certainly discipline for outward information of abusing. But if you had reason that just casted doubt on their stated reason, you could follow up with a recertification. Okay, and a little more information on this. A couple cases that I think provide some insight. So in this Tillman case, there was a situation where the employee was on intermittent leave for a chronic back condition. Because the employer was tracking the usage, they became aware that the employee tended to have occurrences on Fridays, weekends, or around the holiday. The employer investigated and found out that the employee was in fact fraudulently using their FMLA leave, and the court upheld that termination. Obviously, if you're going to make such a move and terminate an employee, you want to make sure that your evidence is solid and comprehensive. Certainly, if you're going to be terminating a represented employee, you'll probably be at an arbitration, and you want to have your evidence in order. But even now, if someone feels they were improperly terminated in violation of their FMLA rights, you'll be at a hearing in front of the Department of Labor or in court. So make sure your evidence is solid. Another case that I thought you might be interested in is this Graham case. Here the employee was out on intermittent leave for migraine headaches. They had missed 28 consecutive days of work, which exceeded the frequency and duration of the original certification. So the employer followed up and exercised their right to try and get a recertification. The employee never complied. And with everything in FMLA leave, initially give the employee the benefit of the doubt. Make sure you follow up. Make sure you make it very clear that you need the information. And in this particular case, despite that the employee never complied, and ultimately the employer then denied the FMLA leave, and they were terminated when they were thereafter absent. And the court upheld that information. In the court decision, the court is very clear that the employer really tried to it made extensive efforts to get this information because the leave was exceeding the original certification, and when the employee failed to cooperate, that's when the employer was within its rights to deny the leave and thereafter terminate. Okay, you do have the right as an employer when it comes to intermittent leave to try and have some influence over when the employee is receiving medical treatment. And depending on the reason for intermittent leave, this may or may not be appropriate. Certainly if someone has migraines and they just call out in the morning when they have a migraine and they report they can't come into work, this tip won't be very helpful for you. But someone who's, say, on dialysis, who needs intermittent leave for treatments, you can have a discussion with your employee about how they can schedule their planned medical treatments in a way that is as least disruptive of the operation as possible. You know, whether they schedule it for early in the day, later in the day, maybe they're off certain days of the week, and you can talk about why, whether they can schedule at that point in time. But again, you have a dialogue, and you know, with most conversations, either under the ADA or under FMLA, you want to have that dialogue with the employee, express what the concern you have is. You know, the machine is running, you know, it's disruptive if the production line has to stop or whatever the reason is. You talk that through with the employee, and you try and see if there's a way for the employee to make that, you know, to have their treatment scheduled in a way that's least disruptive. If they are really being uncooperative, then you may be able to take action and deny it. But again, before you pull that trigger, you want to really you know, work as best as you can to see if you can come to some agreement and give the employee the heads up that, you know, you are finding them uncooperative and you're not sure why they are that way. Maybe there's a reason. Maybe they have competing child care interests that they can't yield on. So you try and make sure you have as full of a discussion as possible. Now, if the person has intermittent leave needs and it's really disruptive given their current position, under the law, you can transfer that person to an alternative position for the period of the intermittent leave. But what's important is they have to receive equivalent pay and benefits, regardless of the fact that other employees in that same position that they might be transferred to have a different rate of pay, because this is seen as a temporary accommodation. At some point, FMLA rights will be expired. So unlike when you have an ADA situation and you're transferring someone to a different position because they can no longer perform the essential job functions of their current position, but there's an available position for which they're qualified and they can perform despite the fact that they're disabled, then you can pay the pay rate of that particular job. But in a situation with intermittent leave, you want to make sure that the equivalent pay and benefits is the same. If there is a benefit that's strictly tied to the proportionality of time worked, then you may be able to reduce. But say, for example, the person's working full-time and full-time employees are eligible for health insurance, part-time employees are not. If they are, as a form of intermittent leave, given a reduced work schedule, you can't then say that they are not eligible for health insurance. You would have to provide that benefit for them. Okay, so that is our presentation. We're just going to take a moment here to check to see if anyone has any questions. And we do. Okay. Okay, let's see. Yes, you can certainly get copies of the slide. They're actually sent to you when at the end of the presentation. If you, for whatever reason, don't receive a copy, feel free to either contact me or Jackie Rowe, and we'll make sure that you receive a copy. So the first question is there a list of approved illnesses for FMLA? No, there are not. The way the statute works is it covers any serious health conditions. Serious health conditions are defined in a way with certain parameters. They are conditions that you seek ongoing treatment, conditions that might require inpatient care. There's various parameters. So you will want to explore with the individual through the certification process what is the nature of their condition, and then determine whether it qualifies as a serious health condition. Obviously, some are going to, be intuitive. Certainly, someone who has a heart attack and who went into a hospital is going to qualify as a serious health condition. Head colds tend not to be, especially if it's the recommended course is just to stay home and rest. But, it really depends on the individual condition. Next question is, if an employee on intermittent leave has, has used all their sick paid time off, can we make them use any accrued vacation time that they may have? I'm so glad you raised this question, because there's a point on one of the slides that I think I didn't emphasize enough, is under the FMLA, employers can require employees to use all paid time off, and that's including vacation time, so sick time, vacation time, or a lot of employers simply now have paid time off. But you have to have a policy that requires that. So you definitely, I recommend to employers that you generally want that policy, because, if someone's out for an extended period of time, most employers would find it very frustrating and difficult to then have that employee go out on a vacation for another period of time. But you have to have that policy, and make it clear to an employee that you're going to require that. The statute also provides that even if the employer doesn't have that policy, the employee has the right to access all paid time off in order to maintain as best as can be their income stream. So, but you can certainly require it through a policy. Okay. If someone calls out and only says it's FMLA related, should the individual be trained to probe further? Well, you know, I think that's a little bit fact specific. You know, I'd want to know, you know, the first time that happened, I would probably take in the information and I'd go back to whoever has the full file for the FMLA. So sometimes the supervisor just takes the call. It's good that they got the information that it's FMLA related, because then you can track it and begin to spend down the person's entitlement. If when that information comes to HR's attention, if you feel like there's reason to doubt that usage, or you're becoming suspicious about the legitimacy, you might want to follow up with the employee. It's a delicate balance between your supervisor. If you're having the system where your supervisor is taking in that information, you want them to take it in, but you also don't want to involve them too much in the person's medical history, because then if they decide to take some adverse employment action, such as give the person a critical review or maybe select them for a layoff, you're setting them up for, well, they knew all the details of my FMLA and they use that against me. So, you know, I would say you sort of take it, you know, in step. And if you have reason to believe that the person is, you know, abusing it, you know, pursue some of the avenues that we discussed earlier in the presentation. Okay. Regarding the new pregnancy law, having this in our employee handbook, which an employee signs an acknowledgement form, will this be sufficient? Yes, as long as they get it on the front end. So for your current employees who have already signed off on their handbook, and you're probably not going to recirculate the handbook for some period of time, I would make a point of you know, sending out a memo or an addendum about the new law, or otherwise just post it in an area, you know, make your own posting in an area where you post other things until you can get those updated posters from the Connecticut Department of Labor. In the past, FMLA was extended to a parent intermittently through the 5th year of the baby birth. Is this no longer applicable? I don't believe that was ever required by law, but certainly employers are free to allow it. What the statute says is employers aren't compelled to permit it. And I believe that was always the case. But certainly employers might permit it. You might find that, one, a nice benefit to give your employees, and if it's not disruptive, it could really enhance morale. Okay, let's see. Okay, can an employee tell the employer that they do not want to take FMLA? Do they have the right to say, no, I'm not requesting FMLA? I love this question too. I've gotten this question at least twice in the last couple months. So if the employee is seeking a leave of absence, meaning they're not coming to work, and it qualifies as an FMLA, you should track it as an FMLA. That is not up for negotiation. And I do hear this frequently. I hear this sometimes in labor negotiations, but if the statute is triggered, then you should run it. You should inform the person that it's being considered applicable and proceed accordingly. Next question, what about oral surgery or extractions? Would that qualify for FMLA? You know, if the oral surgery is day surgery, you know, off the top of my head, I'd have to double check the statutes, whether that would satisfy the definition of serious health condition. Certainly if there's ongoing treatment by the dentist as it relates to the oral surgery, I think there's a good chance it would count, but I'd probably want to double check that. So the person who asked that question, feel free to shoot me an email and I'd be glad to follow up with you on that. I have an employee, next question, I have an employee who is requesting FMLA to go back to his country for surgery. Yes, and the question is, am I within my rights to ask for the paperwork to be completed in English? Yes, because you need to evaluate whether the it qualifies or not. The only way you're going to do that is if you understand it, if you don't have someone at the facility to translate that for you, then certainly you would. In that particular case, it certainly may raise the question. It raised a question in my mind, at least with this little bit of information, whether this may be a circumstance where you might want to request a second opinion given as to why that person needs to travel outside the country to receive the care. And I don't know if the person receives medical coverage through the employer, but it would certainly beg the question whether that is going to be covered by your health insurance. Next question: if one allows for light duty for a pregnant policewoman, but in a department that does not typically have light duty, does that then set a practice or precedent for male employees for light duty work, or none has been previously given? So that is certainly a potential. Interestingly, there was a Supreme Court case not too long ago that involved a sort of a situation where light duty was provided if you had a work-related injury, and the light duty was not provided to pregnant employees, and that created a problem for the employer. So you do want to think about consistency and not making inappropriate distinctions, that you give it for, let's say, just for the pregnant women, but not for a male who might get disabled and who also might then be utilizing FMLA. So you definitely want to think that through. Now, the statute does not require the creation of light duty if that is, not something that's productive. The statute really does contemplate that there is productive work to be done, and therefore, that can be given to the employee. So very much I think there's going to be, and there'll probably be some more exploration of this as the statute, gets underway after October 1st, but you want to probably confer with legal employment counsel when you start to make those light duty accommodations. Next, we only allow an employee to use time they have accrued. They accrue per month. Do we have to give them all their annual vacation sick time, or just what they have accrued to the date? Just what they've accrued to the date. So again, two separate things. So the FMLA, you would have to give them the time off, but in terms of what amount of time do they have available to them to be paid for that absence, that would be controlled by your policy. Can you compel an employee to work on different shift or day than his normal day shift? This is in terms of, I think, a discussion about, accommodation. If someone can't work on their for whatever reason there's an intermittent leave and it's creating a disruption, you might want to talk about whether you can, move them into a different shift that would be less disruptive. And then depending on their reason, you may be able to force the issue. But I think it's going to be very much, again, part of that dialogue that you got to have with the employee, where you express what the concerns are with giving intermittent leave in their present position, and then discuss with them whether there's an accommodation on another shift that might work for them. Okay, how do you count intermittent leave FMLA days, hours or days? So what you're to do is you're to take what the person's normal work day is. So if a person's normal work day is 4 hours a day, for a week, FMLA, the statute speaks in terms of weeks. You're entitled to 12 weeks of leave under federal law, 16 weeks under Connecticut law, and you convert that to, what their day is. So if someone needed in that kind of a work schedule that they needed, so many hours off, you would convert 4 hours times 5 times 12 or times 16, that's the total number of hours that they would have available, and then you would deduct accordingly. Hopefully that's clear, but if not, feel free to reach out. But what you do is take their regular work day, convert it into the weeks that would fall under the statute. When should a person initiate FMLA? Sometimes employees ask me if they need to have the paperwork filled out by their doctor if paperwork has not begun on time for leave of absence. So off the top of my head, I believe it's 30 days prior to the leave. I might be incorrect about that. And if that can't be accommodated, then it's as soon as practicable. You know, certainly someone who's, let's say, pregnant or who's, you know, no surgery is coming up in a couple months because they haven't been able to get in, but they know they have a date coming up. You should try and encourage people to have those kind of discussions so you can staff accordingly. But I think the statutory minimum time is 30 days prior to the leave. Okay, let's see. What if an illness becomes longer than originally planned? Can FMLA paperwork be given retroactively? Well, if they're out on a leave of absence, for any duration, as long as it qualifies for FMLA leave, you should have had that paperwork. When the FMLA has to be extended, that's when you can either ask for recertification or you can just accept it. So let's say I was going out on surgery. I was thinking my recovery period would be 4 weeks, and as it turns out, I'm a little slower recovering for whatever reason. I'm going to need 6 weeks. So the employee should be keeping you informed about that. You might ask for a doctor's note to confirm that the extended period of time is covered, and then you can, and then that 6 weeks would still be covered by the FMLA. If it extends beyond FMLA, and I'll just go off on a little tangent here, if someone is expecting to be out for 16 weeks and they need an extra week, you know, and assuming it's supported by a doctor's note, then you're out of the FMLA world, and you just have to have a consideration about whether that leave presents a reasonable accommodation under ADA or state disability law. Okay, and I think, let's see, if our FMLA is outsourced and it requires the employee to contact the carrier to notify him for tracking and use of PTO, the employee notifies the supervisor but doesn't call the carrier for tracking, how can we handle it? Initially, I would handle that as reminding the employee of the process and making sure they do that. If they persist in violating the process, I would tell them they are putting at risk payment for their leave because they are not following your policy. But I would give them the benefit of the doubt first because they did take the step of notifying the supervisor, remind them of the policy. You might want to do that both orally and in writing, either an email or send them a letter. Make sure they have that contact information so that then they can, it can't be said that they didn't know the process. And our last question, if the person has returned to work and they still continue to have doctor's appointments, is that covered by the FMLA? Yes, this would be probably a situation of intermittent leave because it's still extending from that original serious health condition, and so you should be tracking it accordingly. I hope you all have found this very helpful. If you have any other questions, don't hesitate to reach out to either myself or one of the other members of the Martha Kalina Labor and Employment Group. We are going to be presenting next month. I believe our topic is going to deal with accommodating mental disabilities. So hopefully you will join us for that. And as I mentioned at the beginning, if you have any topics that you think would be of interest to an audience to cover in a webinar, please share those. We'd love to hear from you. Thank you very much.